But there's also been some major Supreme Court cases that we should cover, especially since we're already on the subject, and we spent a lot of yesterday on Joe Biden, which we still have plenty left to talk about. Let's talk with the first major decision, arguably more consequential than anything we talked about in the last couple of days, and we'll put it up there on the screen. And that is what is known as Chevron. The Supreme Court struck down Chevron and curtailing the power of federal agencies. So this one can get a little bit complicated, but the top line that you just need to know is this, is that the power of the administrative state has been dramatically diminished. So the way that it works is that the 1984 case, which was known as Chevron versus the Natural Resources Defense Council, gave rise to a doctrine known as the Chevron Doctrine. Chevron says that if Congress has not directly addressed a question at a center of the dispute, a court is required to uphold the agency's interpretation of the statute as long as it was reasonable. So for example, we will look at what was actually brought. So the case itself focused on a fishery and specifically on a fine. The fine was levied by the federal government on a fishery as a result of an interpretation of a statute that was viewed by the people who were fined as illegitimate and not reasonable. The overturning of Chevron is landmark because it no longer gives the administrative state the authority in order to say that under this reasonable statute and the interpretation that we can exercise certain rules and monetary fines, which means that the administrative state, and specifically now the court system, will have to determine every single action that is done now by the agencies to see if it falls within Congress's mandate to the agencies. The way that it currently works is that the administrative state, and this is one of the libertarian critiques of the government, has expanded far beyond its original purview. The fine example is a perfect one. As Congress says, hey, you got to regulate our waters, they decide that regulation equals fine, but Congress never said anything about fines. Thus, this leads to the striking down of the Chevron Doctrine. What's kind of fascinating is if you look back in time in 1984, is that it's actually Republicans who celebrated that decision because Ronald Reagan was in power, and it empowered the Reagan administration to interpret federal law and administrative law in the way that they wanted. Since then, though, it has become, I would say, the #1 want and goal of the Federalist Society and of a lot of the conservative legal movement, which views the expansion of the administrative state, specifically 1980s onward, combined with the ideological kind of center-left neoliberal revolution, as one which is a quasi-fourth arm of government that is unelected. This gets to the bureaucracy case. Now, the counter to everything that I'm saying is that this effectively means that anytime the government wants to do anything and address, let's say, a novel situation, something like AI or something like crypto or anything like that, that these agencies have no power to respond unless Congress specifically acts and passes law. Now, theoretically, that's the way that I want it to work. But let's also keep this in mind. They don't pass anything these days unless it's aid for Ukraine and for Israel. So this dramatically, kind of leaves it to basically the free market and really could possibly lead to situations getting totally out of control before Congress even wakes up, pays attention, and by that time, it could be too late. So let's go to the next element just to give you some more of the counter. This one specifically focuses on climate. But it is a good example kind of into the mechanisms that are at play here. So for example, the Inflation Reduction Act, right? The Inflation Reduction Act has given these administrative agencies the power to, quote, force energy companies, automakers, manufacturers to curb pollution and to reduce it, unless Congress steps in. However, it means, though, that the EPA will not have nearly as much administrative authority to regulate power plants and others. What they also talk about is that, quote, it authorizes a more muscular muscular posture by the judiciary when reviewing the decisions of the administrative agencies. So the reason why this matters, as you previously saw with Chevron, is that the courts were not really allowed to overrule as long as it was within, quote, a reasonable standard. Now, every single ruling by any of these administrative agencies can be challenged by big business and in the court system. And depending on where they bring the case, depending on the judge, etc., as we all know, you could easily lead to that either getting struck down or tied up in the legal system. It has to go all the way up to appellate courts. As we just saw in our previous segment, this stuff takes a very, very long time. So arguably, as it comes to business and the way that everything is regulated in this country, Chevron getting struck down is a landmark event. Obviously, people who are big government authority figures, which not necessarily on the left, by the way. I spoke with some right-wing figures, and there is actually some concern that the repeal of Chevron will significantly curtail Donald Trump's ability, let's say, to carry out some of the immigration policy that he wants to, if he were to assume office. So there's several things, like with respect to what is known as public charge in welfare, where basically illegal immigrants, depending on the circumstances, could or could not qualify for welfare. That was something that the Trump administration tried the first time around. There was also this huge case around the census. All of these things involve comment, administrative law, and interpretation of the law by the sitting executive, whereas this time around, it kicks a lot of authority to the court. So even though we just had the Supreme Court case about presidential immunity, the Chevron Doctrine significantly curtails the overall administrative state, which by definition means that it will lessen at least some of the power of the federal government, especially in the realm of the economy and determining especially the president's absolute authority over military matters. If you ask me, it should probably be reversed, shouldn't it? Let's also get to the next part, because this is also a highly significant case. This was a case that we led with on the show several months ago. The Supreme Court, unfortunately, rejected the challenge to the Biden administration's contacts with social media companies. And this was a major, major First Amendment case with respect to how the government should interact with social media platforms like Facebook, Google, and Twitter. Basically, what the decision came down to is that the authority and First Amendment rights of Americans is not infringed upon by the government if it has a contact with a social media company, or if it, let's say, whips up a campaign and leads to third-party calls for censorship. It does not violate your First Amendment rights. Now, obviously, this is not the way that I think the decision should be, because there is an implicit threat of power, in my opinion. Let's think about the Alex Berenson case, for example, where you literally have White House officials who are emailing executives over at Twitter and saying, why is this account still up? Now, they're not ordering you to take down the account, but the mere suggestion, and especially in working with conjunction with other groups surrounding the so-called censorship industrial complex, leads to a snowball effect, which could then lead to your digital rights, quote unquote, freedom of speech, to be curtailed. Now, basically what they found, though, is that the executive has broad authority to maintain their contacts with these social media companies. So, for example, this is written by Justice Amy Coney Barrett. The plaintiffs, without concrete link between injuries and the defendant's conduct, ask us to review years-long communications between dozens of federal officials across different agencies with different social media platforms about different topics. This court's standing doctrine prevents us from exercising general legal oversight of the other branches of the government. There was, though, actually a pretty important dissent from Justice Alito, Thomas, and Neil Gorsuch. They say, for months, high-ranking government officials placed unrelenting pressure on Facebook to suppress Americans' free speech because the court unjustifiably refuses to address this serious threat to the First Amendment. I respectfully dissent. Obviously, this White House is very happy about this. The Biden administration said, quote, Supreme Court's decision is the right one. It helps ensure the Biden administration can continue our important work with technology companies to protect the safety and the security of the American people. So unfortunately, a so-called, firewall between the government and these social media companies was not erected by the Supreme Court when they had the opportunity, I think, to really set the standard from the beginning and make sure that there is not collusion going on. Justice Kavanaugh, for example, gave what I thought was a really stupid example. He said, well, under this standard, White House officials shouldn't be allowed to talk to reporters because they're constantly trying to manage the information that is being put out. But that is a single instance for a single paper. That is not the same thing as a platform, especially in a monopolistic environment like the one we're in today, where all of these platforms can simultaneously just take somebody down and dramatically limit their exposure. There's also the so-called shadow banning effect, which of course has no oversight, no insight from the federal government, and which has been highly encouraged, especially during the whole vaccine era, January 6th, misinformation, COVID, Chinese origin of coronavirus. I could go on forever. Regardless, the point is that these two cases are very, very significant. They may even be, frankly, more significant than the immunity case because what we have now is a standard that the government can pressure the hell out of a social media company if they want to take something down that has no infringement on your First Amendment rights, and then also the administrative state and the delegated authority that it previously had without judicial review no longer stand. So take those two things and understand that that is going to dramatically shape the next administration, perhaps the next Trump administration, and it may not be in the way that some right-wingers actually wanted it to be. And we might see some of the First Amendment concerns really come back to bite some of these people in the ass. Any Palestine protesters out there, I may not be so happy about this one, especially if Donald Trump does get elected. Hey, if you like that video, hit the like button or leave a comment below. It really helps get the show to more people.
And if you'd like to get the full show ad-free and in your inbox every morning, you can sign up at breakingpoints.com.
That's right. Get the full show, help support the future of independent media at breakingpoints.com.